Thank you. May it please the court. Good morning. I'm Shay Moxon of Brannick and Humphreys, and I represent the appellant, Howard Caraballo. I'd like to reserve 5 minutes for rebuttal. Mr. Caraballo was the plaintiff in an auto negligence suit, and he won a jury verdict in his favor. But 13 months later, the trial court, after it had already denied the defendant's motion for new trial, reversed itself, entered a new order granting the defendant a new trial on 3 alternate grounds. And each of those was error, but preliminarily, the trial court never had authority to enter that order in the first place.
Let's talk about it. This is kind of a very unusual step that the trial judge did. The facts, it boils down to that expert witness who the judge apparently had personal knowledge as to who is the, quote, the Ray's team doctor. This, what generated this whole granting of a new trial?
That was the main grounds, yes, Your Honor. There's even a filing by plaintiff's counsel that suggested that he wasn't even actually the team doctor. But setting that aside, yes, based on the trial judge's personal belief that his friend, Coco Eaton, was the team doctor, that a misrepresentation had been made when plaintiff's counsel allegedly referred to the orthopedic surgeon as the team doctor in opening statement. But that wasn't what plaintiff's counsel said.
And I understand, because the record, we have the record here. I guess when the witness was testifying, was there any objection by the defense with respect to that representation?
No, and if I may, it goes beyond that. The defendant completely waived this issue. He even repudiated this issue. Did not object during opening statement, did not object during Dr. Tolley's testimony. When the defendant moved for a mistrial at the end of the trial, stated his grounds, none of them had anything to do with his team doctor matter. The trial judge raised that on his own during this motion for mistrial discussion, and he said, well, the issue regarding the team doctor was resolved before he testified. Nobody said anything wrong, so that's not grounds for a mistrial, even though the defendant wasn't moving on those grounds. The trial judge even said at that point, well, the only irregularity that occurred was, and he talks about some other instance, presenting some of the defendant's testimony to knock it down, but he says, the defense attorney adopted that when he said, okay, I'll adopt that ground. The judge says, well, you're not getting a mistrial on that one. So even at that point, the first time the trial judge raises it on his own during the motion for mistrial, the defendant doesn't adopt it, and the judge says it's not grounds for mistrial.
And then help me out, because I know there was a big time lapse, and there was a motion for a new trial.
Yes.
Done, and that was denied. Then there was motions for remitted, and the sequence. So it wasn't until I think you represented about 18 months later, or several, almost like a year and some months later, where the court then sua sponte grants
Yes,
a motion for new trial.
Yes, and his main reason was his team doctor issue, which was not only based on incorrect facts, but I emphasize that the defendant not only waived that issue, completely repudiated it. At one point, the plaintiff filed some court filings related to this issue of what Dr. Tolley's relation to the Rays was. The defendant moved to strike them as irrelevant to any of the pending matters. I counted a total of 6 times that the trial judge raised this team doctor matter on his own, from the second day of trial up through the last post-trial hearing. 6 times the trial judge raised it on his own. The defendant never once said a word to adopt that. So the defendant plainly waived this issue, rejected it, but also it's based on incorrect facts. As I believe Your Honor acknowledged, there was never a representation that Dr. Tolley was the team doctor. And during that discussion on the second day of trial, that's what plaintiff's counsel was advised. Don't have him say he's the team doctor when he testifies. That's all I care about. So Dr. Tolley testified, and he testified that he treats a number of players for Major League Baseball teams, including the Rays, which perfectly supported the representation that was made in opening statement. So both of the premises that misrepresentation was made and it was not supported with evidence were both plainly incorrect on the record. And as I was addressing earlier, there was no jurisdiction to enter this order in the first instance,
Well,
but
let's talk about that. What is the judge's authority in reviewing back to his or her prior orders? And I know you've mentioned that in the brief, and I know counsel on the other side does the same, but once a judge makes a determination on a motion, can that judge go back and revisit, say, you know what, I was wrong, I need to revisit that?
not if it's on a motion for new trial, remediator, or additor. Their case law, it's legion. It doesn't matter if it's an order granting or denying the motion, whether it's on a party's motion for rehearing or the judge doing it sua sponte. I have not found a single case that has ever upheld a trial judge's decision to do that. And that includes situations where a case comes out on the day of the judge's order and says, the judge looks at it and says, oh my gosh, I was wrong, I need to correct this. There's State Farm v. Miller, Fiber Creek Homes. Good reasons to correct it. Of course, in every one of these situations, the judge believes he has good reason to correct it. Well, the courts repeatedly held these orders cannot be modified absent fraud or clerical error. And I believe the concern there is with finality. There is a period and a process that the trial court gets to correct its errors through the post-trial process, but once the post-trial motions have been ruled on, it's time to either enter a final order, a final judgment, or an appealable new trial order so that the parties can proceed to the next step, whether that's appeal or going through with a new trial. Not to drag out the proceedings for another 8.5 months. I mean, it would have been close, but maybe an appeal could have been done by then. But a trial judge doesn't have authority under the rules or any of this case law to extend the proceedings another 8.5 months, ruminating over all his prior rulings and trying to find some ground to undo the jury's verdict.
I'm sorry, go ahead.
No, I'm done. I monopolized too much. Go ahead, Judge Lucas.
I want your thoughts on if we were to hold that an order denying a motion for new trial is interlocutory, and on that point I'd be curious as to your thoughts as to how one defines interlocutory, because there's actually some old case law in Florida that tells us a little bit more about that. Then we could look at the underlying reasoning for why the trial judge decided ultimately to grant this motion for new trial. And the one thing that troubles me, at least, on that is this getting past the Dr. Tolley findings, I guess. Those are what they are. But the notion that this verdict that we have does not pin or have any finding that relates causation to the injuries that the jury ultimately monetized seems to be a flaw. This discharged jury did not give us a finding that the injuries that this plaintiff sustained were caused by the negligence of this defendant. Wouldn't that be a sufficient reason to grant a new trial, because we don't have a sufficient finding here?
No, Your Honor, and I'd be glad to address that. On the verdict form, first of all, the defendant agreed to it explicitly. This verdict form was prepared last day of trial. The judge said, I have a lot of verdict forms on my desk, which is the right one. Defense counsel looked right at it and said, looks like the right one, page 1320, the trial transcript. And it even has a telltale the jury's verdict has this handwritten correction on the second page. Mm-hmm. which corrected a typo that defense counsel himself pointed out. So there's a smoking gun. This is the same verdict form that defense counsel said, yes, Judge, this is the one to use. And the case law is clear. You can't grant a new trial based on an agreed-to verdict form. If it can't be fundamental error. At the worst, it would be invited error. But to the substance of what you're asking, there's actually no error at all. And the reason why, the only type of causation that was eliminated from this verdict form was simply the issue of whether this accident caused any injury, loss, or damage to the plaintiff. That was admitted. The defendant admitted that this accident caused the shoulder injury to Mr. Caraballo. and his own experts, even to the neck. His own experts testified it caused some sprain to the neck. So the defendant actually agreed to a directed verdict on that question, that the accident caused some loss or injury to the plaintiff. And that was the only type of causation that is ever really incorporated into a verdict form. The causation issues that were disputed, which injuries were caused by this accident, which injuries were caused by another accident, which injuries were caused by pre-existing conditions, those are never included in the verdict form. I've cited the standard form, verdict form in my brief. It doesn't have that. That's addressed through jury instructions, and those jury instructions were given. The jury was fully instructed on those issues. The defense asked for 2 standard instructions to support its defense. Pre-existing conditions, aggravation of it, or rather aggravation of a disease or defect, and a subsequent accident instruction. Both of those were given. So the jury was told to only award damages that resulted from this accident, not from pre-existing conditions, and not from the subsequent accident, to the extent that they're able to separate them. So they were properly instructed on causation. The case law holds that you have to look at the verdict form and the instructions as a whole. And this jury was fully instructed on the causation issues that were disputed. Cases I relied on, McNair v. Davis, E.S. Hutton v. Sussman. And so when there's a certain legal standard or finding that's omitted from the verdict form, but it's adequately covered by the instructions, and then in this case I'd add, we're talking about something that's not normally put in the verdict form anyway, the disputed issues. There's simply no error in the verdict form. So to sum up, it was an agreed to verdict form, and there's no error in it regardless. And so, that addresses the merits of the first 2 grounds of the order. The third ground, the trial judge found that the entire verdict was against the weight of the evidence because Dr. Tolley's credibility was compromised by a false claim of credential and because he professed to have a perfect ability to predict the future regarding future medical care. But neither of those things are true. Of course, I've talked that there was no misrepresentation of his credentials, and of course he never said he has a perfect ability to predict the future. He gave his opinions to within a reasonable degree of medical probability. And regardless, Dr. Tolley's testimony wasn't the basis for the entire verdict. Certainly, there's jury's findings on negligence, past medical expenses, pain and suffering. The entire verdict didn't depend on his credibility, but regardless, the judge's reasons for finding him to lack credibility were simply not supported by the record at all. What really occurred is that the trial judge disagreed with his Dr. Tolley's opinion that Mr. CARABALLO would need additional fusion surgeries in the future. That was really the concern here. And that is an instance where the trial judge was going on his own understanding, his own belief of what he believes in medical science is.
In fact, he cited to some medical journal, or
Yes.
This judge, did he do extra outside the record research on his own to basically come to the conclusion that this expert witness's testimony regarding a future surgery is not correct because he did his own independent research in the medical field and comes to a contrary conclusion?
Yes, that's absolutely true. That's what he did. And there was even one of the post-trial hearings, and I don't have the page site handy, but he was talking about how he gets this literature and he keeps up on it and he reads it at home. At an earlier point before he entered this order, he's talking about, well, let's just read a journal article how smoking is worse for fusion patients than being on workers' compensation. So he's clearly showing he's relying on his own opinion of what the medical science is. And he's, in order to throw out medical testimony, expert testimony that was admitted without objection, is clearly acting as a seventh juror, substituting his own views of the facts and what the science is for the jury's resolution of the conflicting expert opinions. It's classically the jury's function. And so there's a severe abuse of discretion. And that goes not only to the issue about the manifest way of the evidence in the last order, but it also goes to his earlier order remitting the future medical expenses from $200,000 to zero. That was based on the same thing. He simply did not believe Dr. Tolley's opinion. He substituted his view of the medical science in place of Dr. Tolley's opinion.
You're at 15.
And then the directive verdict on remitter of past lost wages, that was based on the trial judge's assumption that a doctor's opinion or expert's opinion of disability is necessary to recover lost wages. There's simply no law that requires that. The plaintiff can testify that they were unable to work because of their injury, and we had that testimony in this case. So both remitters, as well as the order granted new trial, every basis is clear abuse of discretion. Ask the court to reverse.
May it please the court, Mark Tinker and Deanne McLemore on behalf of Robert Weir. I'd like to start with what was originally the focus of the panel's questioning, is the judge's jurisdiction. The judge has jurisdiction before entry of final judgment to reconsider any orders that had been entered previously, and the Florida Supreme Court has told us that in Silverstone. What counsel said is, talking about these other cases that say, well,
Silverstone speaks in terms of interlocutory orders, does it not?
it does.
Do you believe that this is an interlocutory order, an order denying a motion for mistrial?
It is an order entered before final judgment. Yes, I do believe so.
So by
And that's-
default, your definition of interlocutory is anything entered before a final judgment?
I believe so, correct. And that is the reason that all of the cases that CARABALLO cites are distinguishable, is they are orders denying a motion for new trial entered after final judgment had already been entered. So that is obviously, that order constitutes rendition, and it transfers potential jurisdiction to this court.
What about,
so this is different.
What about our holding in ACA, Brandon, where we held, and I'm quoting, once the trial court denied the Huiman's original motion for new trial, it had no authority to rehear the matter. And then about 3 or 4 decisions from the 4th DCA, which basically have held the same way. Are you asking us to, in affirming this, aren't you asking us to recede from ACA and conflict with the 4th?
No, because ACA does not say whether or not final judgment was entered before or after. If final judgment's entered before the order denying the new trial, then the order denying the new trial is the date of rendition, and it transfers jurisdiction. The judge can't go back and, take a case, if there's a petition for writ of certiorari that we're having a discovery order reviewed here, the judge can't go back and start changing it while it's on review here, because the jurisdiction has vested with this court. This is the same type of situation where if judgment has been entered and then the new trial is denied, that's it. The judicial labor has ended. But if the new trial motion is denied and there's still no final judgment, the judicial labor has not yet ended. There's still more for the trial court to do, so they can, according to the Silverstone decision, the judge can go back and reconsider any prior decisions made.
Well, let's look at the actual order that he granted. Would you agree with Mr. Tinker that there was never an objection, ever, in terms of when the testimony was given, or even on the motion for mistrial, there was not really a basis to grant the mistrials because of this physician's testimony? And should we be concerned to see a judge interjecting himself into a case and then to come up with his own theory as to why a new trial should be given?
I think there's 2 responses to that. Number one, the judge even cited in his order, the canons of judicial conduct, or I forget the exact term for it, that, if a judge has knowledge that a misrepresentation has been made, they're obligated to act.
So
and
you
this
think
wasn't just the judge. I'm sorry, I didn't mean to interrupt you there. But this wasn't just the judge. He even cited in his order, and it's in the transcript, that when the representation was made, somebody in the gallery stood up and said something.
But
So
didn't they-
it was not just the judge saying, oh, I know. Somebody else stood up and said something from the gallery.
But Mr. Tick, we look at the whole record, but then that later on, the person who supposedly made that statement said, no, I didn't. I mean, it's in the record that indicate that that was really not an appropriate basis. I'm more concerned that if you look at the record itself, what was testified to, no objection whatsoever. It's concerning. I mean, when you think about it, where's the due process in this case?
Well, the judge addressed that right after opening statement, said, I am concerned that a misrepresentation has been made. When you call him to the stand, you need to be careful. You might want to correct that. You might want to clear it up and make sure that there's no misstatement. And then in the order granting the new trial, the judge said, in response to that, there was no proper actions taken. That nothing happened, that there were no actions taken to clear up any misrepresentation that had been made in opening.
So the sanction is a new trial?
Well, I mean, that...
Because this reads like a sanction, doesn't it?
It does, and I mean, that I think runs squarely into where you get our standard of review. I mean, an order granting a new
Which
trial.
adversely affects the rights of the parties who arguably had nothing to do with this misrepresentation, if it even was a misrepresentation, which from my reading of the record, I'm not so sure it was.
Well, it's the semantics game that happened with a team doctor versus the team doctor.
The difference
I
between the
understand that.
definite article and the indefinite article A and the can be miles wide,
I
right?
get that. And then that's why the judge said, I think you need to make that very clear. I think you need to clear it up. And then he said later on that, you know, on reflection, no proper action was taken in response to that, that when Dr. Tully took the stand, he started talking about these athletes that he treats, and that, you know, it just kind of perpetuated. When in opening, they said he's, you know,
It
team
reads what
doctor
it reads.
for the Rays. And so, you know, we get to the abuse of discretion standard, and the judge is the one who saw, did the jury perk up when they heard that? Did they react? What did they do when the person in the gallery stood up and said something? You know, the judge made his own views about there was no permissible reaction to his comments, felt so deeply about the case that he referred it to the circuit's professionalism panel. I mean, he was very adamant about this. And that's the important thing, is the judge was there. He saw how this trial happened. He saw the reaction to the Tully issues. I wasn't there. Mr. Moxon wasn't there. None of you were there. The judge was. He got the person to watch.
Do we have a finding from him that this affected the jury?
In the order, it actually does say that this was the most important piece of evidence, and he believes it prejudiced the case.
Do we have a finding that this affected the jury? Because sometimes we'll see on motions granting a new trial, a trial judge will actually say, I observed the jury. To me, it clearly seemed to have an impact on it. Do we have that here?
No, I do not believe
Okay.
that.
And I guess I go back to, our review is whether or not this judge abused his discretion, correct?
Correct.
So we need to look at the record to see, he is basing his whole granting of new trial on the fact that he was a, quote, I mean, that's important, the team doctor. And if you look at the whole transcript, even in opening statement, he's a team doctor. He's one of, and the implication of a, he's one of several. And there was been really, to follow up with Judge Lucas, no misrepresentation whatsoever. So you have this judge who is relying on inaccurate information in a trial to come to the conclusion that this jury has been so tainted because of the representation that this Dr. Toll is the team doctor. Don't we get to review that and say, well, but that's mistaken.
I think what the record shows is that at this point, when this case was at trial, that he was not even a team doctor for the Rays, that he used to be part of Coco Eaton's practice group and used to do stuff. My personal doctor, Mike O'Reilly, used to treat the Rays. He doesn't anymore, so I wouldn't call him a team doctor for the Rays, but he's got jerseys signed all over his office and everything. So I think that's an issue there as far as the A versus the thing.
And
at
that
the time of
issue
trial,
was
he
so
was not.
important that no one objected?
Well, I'm not sure that at the time anybody knew, other than the judge and the person in the gallery, that jumped up and said something. Once it was there, the judge had already addressed it. There's no reason for a party to object if the judge is proactively already saying, you need to make sure this gets fixed. And then proactively says at the end that you didn't fix it. That I'm not really sure that there's a reason to object. It's kind of like the rule that if you got a definitive ruling on the record, there's no reason to keep pushing the issue.
Sure.
If the judge has already raised it by his own sua sponte, there's no reason to say anything at that point. The judge has already said it.
Your position then, going back to the original jurisdictional, I don't want to call it jurisdictional, but
Right.
authority
Authority,
to
yeah.
authority to act would be a more proper way to call it. The fourth got it wrong. That would be your position.
I
It has
don't.
gotten it wrong for the past few decades.
Well, I don't think any of those cases address the distinction as far as when the order granting the new trial was issued versus when the final judgment was issued.
Collins is on all fours.
I was going to ask you that. You have the
I-
opinion, it's exactly on all fours.
Then I believe it's absolutely wrong because it would be in conflict with Silverstone, and I believe, doesn't it predate Silverstone? I'd have to go back and look at my notes as far as what the dates on the opinion is, but I believe it predates Silverstone, and in Silverstone, the Florida Supreme Court told us, and I believe that was in 1998 is what the date of that one was, that anything prior to final judgment, trial judges have the authority to go back and reconsider their rulings. And if, the Fourth District said something different prior to that, I think Silverstone supersedes it. And so I don't know if you'd be conflicting with them or if you'd just be agreeing with the Supreme Court.
What of the notion that we also have rules of civil procedure that tell us how one can go about bringing these matters to the court's attention, or how the court can act? How do you square what this judge did with 1.530, 1.540, which is that there is no such thing as a motion for rehearing to an order denying a motion for new trial, and that therefore the court could not be sua sponte acting on this because, in fact, a party could not have even brought this?
Well, I think that's the distinction, is the rules say that there's no authority for a motion, so it was too late for the parties to do anything about it, but the judge, prior to entry of judgment, has the sua sponte ability to reconsider all prior rulings.
You really
So-
believe this was sua sponte? I mean, this came about after a motion for rehearing, motion for reconsideration, and my goodness, the judge actually convened a hearing on it, and then later enters the order. I mean, was this really sua sponte?
Well, it was done on his own volition. It wasn't, pursuant to a motion that had been filed, so I think that qualifies as being a sua sponte ruling. He decided that he thought an injustice had happened, he thought there was a problem, and, I want to actually kind of circle back a little bit here and remind the court that we're not just talking about the Dr. Tolley issue. There were the other issues that he talked about in his order, the failure to include causation on the verdict form. I know there's been a discussion.
Okay, well, let's talk about that, Mr. Taker,
Okay.
because, I mean, if anything, this is invited error. Looking at the transcript, the defense clearly agreed to that. Never even once brought that, oh, no, we have a question with that. And
Well, we did submit our own proposed form, which had the question on it.
But
And
that's
then
not enough.
I don't understand what happened
That's not
afterwards on
enough.
the transcript.
I
But
understand that, but that's not enough. And based on our case law, there has to be an objection. There has to be, nothing was preserved, and basically, then you have on the record that, yeah, they agreed to that. So why now?
I think
You think it's
because
okay?
the judge decided that given all of these circumstances that a justice had occurred, and he expressly says that in his decision, there are things that happen during trials that maybe there's no objection to it. Somebody, starts referencing liability insurance in a negligence case. Somebody starts doing something, the judge can say, wait a minute. Somebody starts disparaging people in a case for saying, oh, I paid all my policy limits, I've paid for so long, I've been a good customer, and now you're abandoning me on the street. The judge can say, hold on, stop this, and fix it. Even if there's no objection made, the judge can realize that something bad has happened and that there's an injustice and it requires a new trial. And I think this falls under the same situation as the judge, upon reflection, and I mean, his order details that. He says, I went back and I've looked at everything, I've given it careful thought, and I've decided that after looking at everything, I think an injustice has happened here, and the canon of judicial administration says, when I find this way or I feel this way, I'm obligated to fix it.
And how
And
do you-
that's what he did.
How can you, I'll be curious to hear you respond to the judges making reference to this to this medical journal, and basically says, here's this expert testify that, no, that expert is wrong, because I believe, based on my research, isn't he interjecting himself in the case? How do you respond to that, Mr.
I think that, I mean, that it was in a footnote in his decision. I don't think that was a basis for his opinion. He said, this is, you know, I don't believe anybody can possibly do this with absolute certainty, but that wasn't the basis for his decision to order the new trial. The basis was the Tolley thing, the causation thing. He said manifest weight of the evidence. He said, referenced the prejudice that he thought it caused to the jury with all of these things. And again, you know, abuse of discretion, and with orders granting a new trial, it's even a higher standard, which I've never really understood the definition of that, because if abuse of discretion by itself is no reasonable person could have done this. I don't know how it gets higher than that, but the courts have said it's a higher standard than even that. And he's the one that saw these things, and he said, I think this influenced the jury.
I mean, quite frankly, Mr. Galli, it was kind of surprising to read the order, quite surprising to read the judge's conclusion, particularly when you look at the record and everything that he bases in his order, not supported in the record, not objected to in the record, excuse me, and then to have that, and I guess my main concern at the end, where's the due process? Especially, it wasn't at the very end when the judge was going that direction. Well, Judge, give us an opportunity. Let's bring in, if your concern is that you come to the conclusion that he misrepresented being one of the team doctors, there was an affidavit submitted by the Rays. They were asking for a hearing to at least to have the judge reconsider his conclusion, and he made up his mind. He has his order. It was a bit troublesome to read, quite frankly.
And I think all of that goes back to, you know, what the judge observed during trial. It had already, you know, whether people want to bring proofs after trial to try and, you know, prove something different, the judge observed what these statements were, observed the person in the gallery jumping up and saying that's not true, and saw, you know, how this affected the jury. And we can't, you know, the record isn't going to show that. We can't quite, that's what I mentioned earlier. I wasn't there, Mr. Moxon wasn't there, you weren't there. We can't recreate that on a record, but the judge was personally there.
We have, under your reading of the facts then, two parties who suggested the doctor's testimony was untrue, neither one of whom was sworn in as a witness, neither one of whom was subjected to any cross-examination. The unknown witness in the audience, whoever that person was, and the judge who says, I'm going to be a fact witness, I'm going to find myself credible, I'm going to find as a matter of law this as a result. It seems like he is blurring all the, to borrow a phrase, the separation that we have between jurors, or the trier of fact, the advocates and the lawyers, and then application law. It appears that he put on each of the hats. And we wouldn't tolerate a challenge as Judge Kozam saying, wait a minute, Judge, your assumption that you're factually correct is inaccurate. At least give us a chance to dissuade you. And he says, no.
Even if he was wrong, which I don't think the record reflects that he was, but even if he was, he saw the effect of what happened at trial, especially, you know, the unknown person in the gallery, even if they weren't sworn in as a witness, the jury sat there and saw that. And, you know, he was entitled to say, you know, I think this, you know, was a skunk in the jury box now. You can't unsmell it. It's there. You know, the notion was thrown out that what he said wasn't true, and then it wasn't ever fixed. And he said, I gave you every chance to fix it. You didn't make it clear to the jury. You didn't fix it. And at the end of the day, he looked at everything all put together and said, I think that an injustice has happened here.
I want to take you to the remitter or ruling that the judge made in this case. It seems to me that much of what colored the order declaring mistrial and ordering new trial also colored the remittitor ruling, which is to say, the judge basically saw what it perceived to be these problems with Dr. Tully's testimony, with his ultimate findings. But one thing that kind of jumped out at me, and I'd like your thoughts, the trial judge seemed to be under the impression that he was required to make, and these are his words, a qualitative assessment of the evidence supporting the damages that he ultimately decided to enter a remittitor. Can you address that kind of? It just struck me as a somewhat novel view of what the court's role in remittitor is.
I think there's two responses. I think that's a weird choice of words. I agree with you. I think it was more a manifest weight of the evidence type of approach. But I think the second issue is, in our view, because he granted a new trial and we believe that the new trial order should be upheld, that's a moot point. They're going to get another shot at it, and if a second jury says you get all these damages, okay. But I think it's a moot point, depending on, I guess, what the court decides as to the primary issues.
If it were to moot point, how would you tackle this? If we were, let's say we were only here on the remittitor, how would you tackle that? We've got a trial court here that has said, I need to take a qualitative assessment of Dr. Tully's testimony. I think he's coming out wrong. There's no support for it in the literature, and I don't think anyone could possibly make these findings about future medical expenses. It needs to be remitted accordingly. What's your thoughts on that?
I think that's a manifest way to the evidence analysis. He's looking at all of the fact testimony he received, all of the other expert testimony that he saw and witnessed, and then he's looking at what Dr. Tully said and his opinion, and he said manifest way to the evidence. I don't believe that damage award was appropriate. Unless the court has any other questions, I thank you for your time.
You're right on time as well. Thank you.
It's true that I wasn't there and Mr. Tinker wasn't there. The court reporter was there, and there were a lot of findings in that order 13 months later that Mr. Tinker is relying on that are simply not true. I've gone over them ad nauseum, and it's, for example, the discussion on the second day of trial. Plaintiff's counsel, he wasn't told to put some qualification on Dr. Tully's testimony or to correct anything. What he was told was, do not have him say that he is the one person who holds that title, meaning just don't have your doctor say he is the one and only team doctor for the Tampa Bay Rays. The judge also said, I don't care how you phrase it, just don't say that. And so that instruction was followed. Dr. Tully never claimed to be the one and only team doctor for the Tampa Bay Rays. At the end of the day, the judge is complimenting the attorneys for doing a good job and hadn't done anything bad. Joking, usually I would have threatened to declare mistrial 4 times by now, implying, nope, everything's been peachy. 13 months later, he's finding in his order that plaintiff's counsel did something horrible by failing to do the very thing the judge told him not to do. And it all gets back to the fact that 13 months after the verdict, the trial judge had a completely false recollection of what happened.
Can you reference Mr. Tinker's argument about Silverstone?
Silverstone, well, it's not true that any order entered before final judgment is interlocutory. Courts have held explicitly an order granting new trial is not interlocutory because it confers a substantive right. The 4th DCA extended that same reasoning, at least implicitly, to orders denying new trials in State Farm v. Miller, and then continued following that line, Collins v. Douglas, which, as you all point out, is on all fours. That was well after Silverstone. That was decided in 2004. I think Silverstone was 1998. this court's decision in ACA Brandon v. Holtman, that was also after Silverstone. And ACA Brandon, it very strongly implies that there was no judgment entered in that case either, because the remedy ordered at the end, we directed trial court to enter judgment in accordance with the jury's verdict. Not reinstate the judgment, but enter a judgment as if one had never been entered. There are other cases, well, Owens v. Jackson, it's another case that suggests that no judgment had been entered, at least it didn't say there was. And so whether there's a judgment entered or not is not determinative. The cases are universal. A court has no authority to rehear or reconsider orders granting or denying new trial or remitter. This matter about the person jumping up from the gallery, supposedly saying it was wrong. You know, it's interesting. The trial judge's recollection, even on that subject, changed over time. I believe, I'm going just by recollection, but at some point earlier in the proceedings, and I think it's the original order on the motion for new trial, and one of his footnotes, he's talking about how a person jumped up and said that, well, perhaps Dr. Tolley treated some people for the raise. And that's it. And then the judge goes on to write, well, that suggests that maybe that person knew this was false. Not that he actually said it was false. Then 8.5 months later, the order granted a new trial. Now it's this person's jumping up and saying it's false. And then, of course, as Judge Kazan pointed out, that very same individual filed an affidavit saying that wasn't true at all. And that did not occur in the jury's presence. It was during the bench conference, the morning of the second day of trial, when the judge brought this up before the jury was brought in and seated. Let's see. I believe I've covered all these issues thoroughly in my briefs and my initial presentation, and I believe it appears the court understands my position. Oh, on the due process issue, although there was a serious due process violation, this order is reversible on its own merits simply for being unsupported by the record and showing an invasion of the jury's province. So I think the court should simply reverse the order, and any remedy based on a due process issue, that would only be a secondary request for relief. Of course, if the court gets past that and says, yes, well, this order holds up, then we'd possibly be entitled to a new hearing for due process reasons, but I don't think the court needs to get there because this order simply does not stand up. The trial transcript shows that the findings are flatly incorrect, and the judge departed from his role. One last thing I remembered. That little footnote that gives about Dr. Tolley and the false claim of credential, perfect ability to predict the future, well, those are the judge's only reasons he gave for finding the verdict against the manifest weight. An order granted a new trial based on manifest weight of the evidence has to give reasons for it. If it doesn't, as Mr. Tinker just argued, then it's reversible for that reason. If it does give reasons, then the court's review is limited to those reasons, and if they don't hold up, the court has to reverse.
Thank you. Your time's expired.
Thank you.
Thank you both.